The Equal Protection Clause of the 14th Amendment has been instrumental in shaping many court cases and federal statutes that are directed towards preventing discriminations in schools. Discrimination is defined as a determination that an individual or group of individuals, such as African Americans, women, people with disabilities, have been denied constitutional rights. The Equal Protection Clause was reinforced in statutes such as Title IV, Title VII, and Title IX. Title IV, no person in the U.S. shall, on the grounds of race, color, or nationality, origin, be excluded from participating in, be denied the benefits of, or be subject to discrimination under any program or activity receive federal funding. Title VII, it shall be unlawful employment practices for an employer, 1, to fail or refuse to hire or to discharge any individual or otherwise to discriminate against any individual with respect to composition, terms, conditions, privileges of employment because of such individual's race, color, religion, sex, or nationality origin. Or to limit, segregate, classify his employees or applicants for employment in a way which would deprive or tend to deprive an individual of employment opportunities. Title IX, no person in the U.S. shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subject to discrimination under any educational program or activity receiving federal funding assistance. Since 1964, the Civil Rights Act, numerous statutes and court cases have encouraged steps designed to ensure that underrepresented populations have equal opportunity. These affirmative action initiatives have included such actions as formalizing and publicizing non-discriminatory hiring procedures, setting aside a certain number of slots for minority students, and hiring or college admissions programs. It has come to light the possibility of reverse discrimination, situations in which a majority or an individual member of a majority is not accorded equal rights because of a different or preferential treatment provided to a minority or an individual member of a minority. The judicial basis for current approaches to education of students with disabilities is also closely linked to the Civil Rights and Equal Opportunity Initiative. Statutes are Section 504 of the Rehabilitation Act, Public Law 94-142, the Educational for All Handicapped Children Act, and the Individuals with Disabilities Act. Section 504. Under this Civil Rights Act, established in 1973, recipients of federal funds are prohibited from discriminating against otherwise qualified individuals. It addresses equal treatment, appropriate education, and people with disabilities. Equal treatment, as in other civil rights contexts, must be addressed. However, this does not necessarily mean the same treatment. Public Law 94-142, first passed in Congress in 1975. This law ensures a free, appropriate education to all children with disabilities between the ages of 3 and 21. Children with exceptional needs cannot be excluded from education because of their needs. Detailed plan must be spelled out in writing. An IEP formulated by general and special education teachers and subject to parents' approval. Two priorities for funding were identified. 1, child who currently receives no education, and 2, the child who is not receiving all the services he or she needs to succeed. Individuals with Disabilities Education Act, also known as the IDEA. This statute addresses how states and schools and other public agencies provide services to children with disabilities. The purpose for IDEA is to make available to all children with disabilities a free, appropriate public education. Adding rigor to IDEA. In 2004 reauthorization of IDEA, there was a need to align IDEA with No Child Left Behind, NCLB, including making consistent such as definitions as highly qualified teachers and limited English proficient, and heavy emphasis placed on scientific-based research in the classroom. Response to intervention, RTI. There needs to be a systematic approach to assessing what the student already knows and identifying needs. Secondly, document the efforts must be made to improve the student's learning by providing student needs specifically and research-based interventions. The 14th Amendment gives every citizen the right to due process of law, both substantive due process and procedural due process. Most court cases related to teachers involve either liberty or property interest. Liberty interests are created by the Constitution itself. Property interests are found in form of legal entitlements such as tenure or certification. Conditions of employment typically include your successful completion of professional preparational programs, licensed by the state, and receiving a contract from the hiring school district. The primary purpose of each state's teacher certification licensure is to make sure that the teachers in public schools are qualified and competent. Certification laws usually require satisfactory completion of preparational programs, citizenship, no criminal record, and increasingly evidence of instructional effectiveness. Establishing rules and procedures for obtaining a teacher license will be responsible by the State Educational Board. Boards of education have the statutory authority to employ teachers. This authority includes the power to enter into contracts and to fix terms of employment and compensation. The role of the superintendent is to screen and to nominate candidates to the board. The board, meeting in official session, then acts as a group to enter into a contractual agreement. Teacher contracts usually include identification of the teacher and the Board of Education, a statement of legal capacity of each party to enter into a contract, a definition of the assignment specified, a statement of the salary, and how it is to be paid, and provisions for signature by the teacher and by the legal authority agents of the board. The contract is not official until it has been signed by all parties. Tenure laws are intended to provide scrutiny for teachers in their position and to prevent removal of capable teachers by capricious actions or political moves. Beginning teachers are not automatically tenured. A teacher becomes tenured by serving for a period of stated time. This period is referred to a probational period and typically is 1 to 3 years. Even with tenure, teachers may be dismissed for any one of numerous reasons, such as non-performance of duty, incompetency, insubordination, conviction of criminal involving moral turpitude, failure to comply with reasonable orders, violation of contract provisions or local rules of regulations, persistent failure or refusal to maintain orderly discipline of students, and revocation of teacher certification. Although due process has been applicable for years to tenured teachers, non-tenured teachers do not, for the most part, enjoy the same rights. Tenured teachers enjoy 2 key rights: protection from dismissal except for cause, as provided in state statutes, and right to prescribed procedures. Non-tenured teachers may also have due process rights if these are spelled out in the state statute or the teacher's contract. However, in most districts and states, non-tenured teachers may be non-renewed without any reason. Collective bargaining. Teacher groups meet informally with boards of education to discuss salaries and other teacher welfare provisions. Collective bargaining is a process through which teachers are represented as a unit to negotiate with the school board terms and conditions of employment. The collective bargaining unit, such as the teachers union, meets with representatives of the district, such as the assistant superintendent for human resources. Through bargaining, an agreement is reached that applies to all teachers. This procedures must comply with the National Labor Relations Act, and collective agreements is enforced under state law. Some school districts, however, meet with the board instead of the assistant superintendent. Academic freedom is the freedom to control what one will teach and to teach the truth as one discovers it without fear of penalty. Academic freedom is thus essentially a principle of pedagogical philosophy that has been applied to a variety of professional activities. A philosophical position, however, is not necessarily a legal right. Although federal courts generally have not recognized academic freedom for elementary and secondary school teachers, most supportive rulings have been made in the 1980 court case. This case involved a high school history teacher whose contract was not renewed after she used a simulation game to introduce her students to the characteristics of rural life during post-Civil War Reconstruction area. Although the role-playing evoked controversial in the school and the community, there is no evidence that the teacher's usefulness has been impaired. Therefore, the school erred in not renewing the teacher's contract, and she was ordered to be reinstated. It's hard to define the limits of academic freedom. However, in general, the courts strongly support it, yet recognize that teachers must be professional and responsible when interacting with pupils. Teachers are not free to disregard a school board decision about which textbook to use, but they have more freedom with the choice of supplementary methods. Teachers have usually been supported in their rights to criticize policies of their local school board, wear symbols representing stated causes, participate in non-popular movements, and live unconventional lifestyles. But when the exercises of these rights can be shown to have a direct bearing on a teacher's effectiveness, respect, or discipline, these rights may have to be curtailed. In 1974, Congress passed FERPA. This statute addresses the maintenance of confidentiality of student records. This statute does not prohibit teachers, principals, and other educational professionals from making student information available for educational purpose as long as they take steps to maintain privacy of the information. Many school administrators and teachers and most parents do not realize that parents have the right to view their children's educational records. Many teachers are not aware that their written comments, which they submit as a part of student records, must be shown at the parent's request or in response to a student's request. With more than 55 million students in U.S. public schools, it is almost inevitable that some pupils will be injured in educational activities. Each year, some injuries occasion lawsuits in which plaintiffs seek damages. Legal actions seeking monetary damages for injuries are referred to actions in tort. Tort is a legal wrongdoing, an act that violates private rights of an individual. Actions in tort are generally based on allegations of negligence. In other words, the basis of tort liability or legal responsibility is negligence. Liability is responsibility for negligence, responsibility for the failure to use reasonable care when such failures results in injury to another. Teachers have the duty to protect. It is the belief that teachers must anticipate dangers and take action to protect students from foreseeable harms. Legal negligence is the failure to exercise or practice due care. Capable and negligent by a teacher is the performance of his or her duties is called educational malpractice. Liability insurance. Many states authorize school districts to purchase insurance to protect teachers, school district administrators, and school board members against lawsuit. It is important that the school district and their employees and the board members thus be protected either through the school district's insurance or through their own personal policies. People have wondered whether it's legal for a school district to monitor the emails of its teachers or the college where you study teacher education to read your emails. If you use the college or school district's email system, then yes, they can monitor your emails. Social networking. Content that is of the personal or sexual nature will become the basis for dismissal. Even the accidental discovery of inappropriate content can lead to the employee being fired. The innocent acts of youth can lead to legal proceedings, as teenagers in several states have discovered with sexting. In several cases, officials have threatened to charge or actually doing so girls who allegedly sent nude photos of themselves with lewd exhibition and boys who received the photos with possession of child pornography. The misuse of social networking by students may be viewed as happening through the innocence of youth. Similar behaviors by teachers are inexcusable and they are being prosecuted. Cheating with technology. Instances of using a cell phone while taking a test to snap pictures of test items and having an outsider call and the correct answers are more common than teachers want to believe. Plagiarism on term papers is another problem. Fortunately, several websites and services are available that can be used to catch those who copy from publicized texts.